The program today I will be presenting, which is Conflicts of Interest Rules for Neutrals, comparing ABA Model Rules of Professional Conduct and States Rules of Professional Conduct with the rules of the American Arbitration Association, the Financial Industry Regulatory Authority. And then there's a set of rules for mediators as well, which I'll mention later. My background, briefly, you have all the details in the invitation to this meeting, but I'm licensed to practice law in New York and Florida. In addition to being chair of this committee, I am now the chair of the Ethics and Professionalism Committee of the Senior Lawyers Division, and I urge all of you and everyone you know who has any interest in attorneys' ethics and the conduct, ethical, and fiduciary duties of lawyers, regardless of what role they fulfill, including roles in government. And that's going to be our focus, of course, in the next year or so, is lawyers who are working in government and their duties and what we can do to make sure that they fulfill those duties. I would appreciate you would register to become a member of that committee. There's no commitment of time or money to be a member of that committee, but I am eager to get ideas and strategies from as wide a swath of members of the ABA as possible on strategies we can take as an ethics committee to do what we can, both to defend the American Bar Association, which some of you are aware is under direct attack by the executive branch of this government, as well as to fulfill our duties to the American people to make sure that all lawyers in whatever role they take in our society are fulfilling their ethical and fiduciary duties. So in addition to being involved with those committees, I am a member of the section of dispute resolution and the member of this dispute resolution committee and professional responsibility committee of the business law section of the ABA. I am also a member of the professional responsibility and professional discipline committees of the New York City Bar Association, and I'm a former member of the professional ethics committee of the Florida Bar. I taught ethical and fiduciary duties of lawyers in law schools and in paralegal studies programs, and I have been qualified by courts as an expert witness on attorney standard of care in legal malpractice lawsuits, and I've done about 10 of those. So proceeding now with the program, the presentation is going to focus primarily on ethics rules applicable to lawyers as neutrals, as distinguished from ethics rules applicable to lawyers that represent parties to ADR proceedings. But regarding the latter, the lawyers as advocates, I point out that binding arbitration is defined as a tribunal for the purposes of the American Bar Association Model Rules of Professional Conduct, and lawyers representing parties are subject to duties of candor prescribed by Rules 3.3 and 4.1 of those model rules, as well as all of the other rules of the Rules of Professional Conduct in effect in each state in which they're licensed to practice law. Now, the ABA model rules, like the rules in effect in individual states, have some extensive definitions that inform the meaning of the respective rules. I'm not going to go into all of those definitions now, but I did point to them in Rule 1.0 of each of these respective rules. And if you have any questions as we go through on what any of these terms mean, and we have time toward the end, I can answer some questions about what those respective rules mean. The really only 3 rules of the model rules of professional conduct directly relate to the operation of a lawyer as a neutral. One is Rule 2.4, entitled Lawyers Serving as a Third-Party Neutral, which focuses primarily on communications between neutrals and parties to arbitration proceedings and their attorneys. As noted in comment 2 to Rule 1.12 and comment 2 to Rule 2.4, other law or codes of ethics governing third-party neutrals may impose more stringent standards of personal or imputed disqualification. For example, the other rule with which lawyers who are acting as neutrals should become familiar are the Code of Ethics for Arbitrators in Commercial Disputes. Something's happening here. Somebody putting up a screen share?
Yeah, whiteboard.
I don't know what. Okay, I'm not going to be using it, but thanks, Steve.
I think I
Okay.
accidentally clicked on something. I had my hand on the mouse. I'm sorry.
I'm sorry?
I say I had my hand on the mouse and without realizing it, I think.
Oh, okay. Well, why don't we bring that down so we can see everybody? Okay. So Rule 2.4, entitled Lawyer Serving as Third-Party Neutral, again, as I mentioned, points to other rules that could be more specific and more extensive than the model rules. Actually, as you'll see when we go through this discussion, they are not more extensive. But the relative rules are the Code of Ethics for Arbitrators in Commercial Disputes, which was developed by a joint committee of special committees of the American Bar Association and the American Arbitration Association. That was prepared in 1977 and revised in 2003 by an ABA task force and a special committee of the American Arbitration Association. Another rule is the ABA, the AAA, and the Society of Professionals in Dispute Resolution, who prepared the model standards of conduct for mediators. That was adopted as revised in early fall 2005 by the ABA House of Conflict Resolution. It's a merged organization of the Academy of Family Mediators, the Conflict Resolution Education Network, and the Society of Professionals in Dispute Resolution, and the FINRA Dispute Resolution Services Arbitrators Guide, revised in April 2023, which includes guidance to arbitrators regarding, among other matters, their ethical considerations and duty to disclose. Steve, can we try to take that whiteboard down?
There's a tab at the top. If you just switch to meeting versus Stephen Fellenstein's
I am not the host.
whiteboard.
The host is not present in the meeting, so I don't know how Steve did it. But I think Steve put it up. Steve has to take it down. I'm going to say stop. I don't know what that means. That did it. I said stop. It said stop. Was that what you were pointing to, Howard? Okay. Very good. Well, that worked. Whatever. All
These
right.
are
So
senior lawyers here.
right. I've never seen that situation before when I wasn't the host. Okay. Under Model Rule 2.4, a third-party neutral is anyone providing services as an arbitrator, mediator, or another capacity that will enable the lawyer to assist the parties to resolve the matter. A lawyer serving as a third-party neutral must inform unrepresented parties that the lawyer is not representing them. That seems apparent, right? But apparently it's not always obvious to the parties, particularly if they're proceeding pro se, that the arbitrator is not serving as their lawyer. When a lawyer knows or reasonably should know that a party does not understand the lawyer's role in the matter, the lawyer shall explain the difference in the lawyer's role as a third-party neutral and the lawyer's role as one who represents a client. Two very different roles. Comment 3 to Rule 2.4 says, where appropriate, the lawyer should inform unrepresented parties of the important differences between the lawyer's role as a third-party neutral and a lawyer's role as a client representative, including the inapplicability of the attorney-client evidentiary privilege. The extent of disclosure required under this paragraph will depend on the particular parties involved and the subject matter of the proceeding, as well as the particular features of the dispute resolution selected. So the onus is on the neutral to be very heavy on communication with the parties and their counsel. Standard IA2 and Standard 6A5 of the Model Standards of Conduct for Mediators regarding self-determination of each party and quality of the mediation process also encourage mediators to counsel parties to consult with independent professionals and to distinguish between the roles of mediator and other professionals. Comment 4 to Rule 2.4 states, a lawyer who serves as a third-party neutral subsequently may be asked to serve as a lawyer representing a client in the same matter. The conflicts of interest that arise for both the individual lawyer and the lawyer's law firm are addressed in Rule 1.12, which we're going to be touching on shortly. Now, the second model rule that implicates neutrals is Rule 3.9, entitled Service as Arbitrator or Mediator, regarding judges serving as neutrals. That rule provides that a judge may not act as an arbitrator or mediator, such as participating in arbitration, mediation, or settlement conferences. And comment 1 continues that unless expressly authorized by law or performed as part of assigned judicial duties, which would be exceptions. Of course, this rule does not preclude a judge's acting as a neutral after the judge has ceased all services as a judge in all courts. So retired judges certainly are welcome to be neutral. So that's not prohibited by Rule 3.9. Then maybe the most significant of the three rules I'm going to be touching on here is Rule 1.12 entitled Former Judge, Arbitrator, Mediator, or Other Third-Party Neutral Conflicts of Interest. And what motivated me to give this talk today was Howard's reference in his very excellent talk about international arbitration, about the problems of not only confidentiality, but also conflicts of interest in international arbitration. And I said, well, that's a big deal, even in domestic arbitration. So I think we're going to do a program that's going to focus on that. That Rule 1.12, as I said earlier, is referenced in Model Rule 2.4 regarding communications. And provides that except that an arbitrator selected as a partisan of a party in a multi-member arbitration panel is not prohibited from subsequently representing that party, except for that exception, a lawyer shall not represent anyone in connection with a matter in which the lawyer participated personally and substantially as an arbitrator, mediator, or other third-party neutral, unless all parties to the proceeding give informed consent confirmed in writing. Remember the confirmed in writing piece, because when we get to California, we're going to see that they don't require the confirmed in writing. So the difference is the devil's in the details when it comes to states' rules of professional conduct. We need to pay attention to the rules in effect in our respective states. Canon 1C of the Code of Ethics for arbitrators in commercial disputes and standards 2, 3, and 5 of the Model Standards of Conduct for Mediators include similar restrictions on taking on a relationship with anyone involved in an arbitration after an arbitrator ceases to be in that arbitration itself. Because, as stated in Comment 3 to Rule 1.12, third-party neutrals typically owe the parties to ADR an obligation of confidentiality under law or codes of ethics governing third-party neutrals, even if they do not have information concerning the parties that's protected under Rule 1.6 regarding confidentiality. If a lawyer is so disqualified from knowingly undertaking or continuing representation in the matter, unless the disqualified lawyer is timely screened from any participation in the matter and is apportioned no part of the fee therefrom, and written notice is promptly given to the parties at any appropriate tribunal to enable them to ascertain compliance with the provisions of this rule. So essentially what we're saying is this is the imputation rule to other lawyers in the firm, in which the lawyer who is disqualified because he or she was an arbitrator in a case, that imputation can be negated with satisfaction of three conditions. And that is the screening, a portion of no part of the fee for that particular matter, that would be the conflicted new matter post arbitration, and written notice to all the parties and any appropriate tribunal to enable them to ascertain compliance with those other two restrictions. This comment 4 to that Rule 1.12 in the model rule says that this restriction does not prohibit the screen lawyer from receiving a salary or partnership share established by prior independent agreement with his or her firm, but the disqualified lawyer may not receive compensation directly related to the matter in which the lawyer is disqualified. Under Comment 5 to Model Rule 1.12, this notice, including a description of the screen lawyer's prior representation and of the screening procedures employed, generally should be given as soon as practicable after the need for screening becomes apparent. Now, another restriction provided by Rule 1.12 of the model rules is that a lawyer shall not negotiate for employment with any person who is involved as a party or a lawyer for a party in any matter in which the lawyer is participating personally and substantially as an arbitrator, mediator, or other third-party neutral. This rule provides no exception to this prohibition against negotiating for employment for an arbitrator that was selected as a partisan of a party in a multi-member arbitration panel, although that arbitrator is not prohibited for subsequently representing that party. So note the inconsistency there. If an arbitrator could, after the conclusion of an arbitration case, could subsequently represent a party to that case as a lawyer in a matter that's unrelated to that particular arbitration case, but can't apply for employment. So I suppose threading that needle, if a partisan on a 3 arbitration panel, in other words, an arbitrator that's appointed by one of the parties, and everybody understands that that arbitrator is appointed by one of those parties and is likely to be less than neutral with respect to that party, that lawyer or arbitrator could be solicited by that party after the case concludes to represent that party in a wholly unrelated matter, but that partisan arbitrator could not actively seek to be retained as a lawyer in a subsequent case. The rule, however, does not prohibit another lawyer in the firm of that lawyer with which that lawyer is associated from negotiating for employment with any person who was involved as a party or as a lawyer for a party in any matter in which the first lawyer participated personally and substantially as an arbitrator, mediator, or other third-party neutral. So what's important in understanding that part of Rule 1.12 is understanding what personally and substantially participating means, and comment 1 to Rule 1.12 of the model rule signifies that a mediator or an arbitrator who is a member of a multi-member panel and thereafter left service as an mediator or arbitrator to practice law is not prohibited from representing a client in a matter pending for mediation or arbitration, even on the same platform. So say even on American Arbitration Association platform, if the previous matter was on AAA platform, but in which the former mediator or arbitrator did not participate. So if Howard were an arbitrator on a AAA case, and after that case concludes, one of the parties to that case seeks to hire him as a lawyer to represent that party in a wholly unrelated arbitration case, which also happens to be on the American Arbitration Association platform, Howard would be permitted under the ethics rules to do that. The rules of professional conduct adopted by the attorney supervising governmental authorities in different states, however, as I mentioned, are not identical to each other or to the model rules of professional conduct. So I can't say it too many times. Lawyers should always check the rules in effect in every state in which they are licensed to practice law to find the detail in the weeds requirements for them with respect to those states. And again, it doesn't matter where you're providing legal services. What governs what rules apply to you is where you are licensed. You must thread the needle. You have to comply with the most stringent rule of any rules of professional conduct in effect in any state in which you are licensed. So if you're licensed in 5 or 6 states, as some lawyers are, you've got work to do to try to figure out how to reconcile them so that you're complying with the most stringent of all of those states. Canon 10 of the Code of Ethics for Arbitrators in Commercial Disputes we don't necessarily see very often, but some arbitrators in some areas of concentration of subject matter and arbitration do see 3 arbitrated panels in which two of the panelists are appointed by the respective parties, and the third panelist is appointed by the 2 panelists that were so selected by the parties. And so there is less than full neutrality there of at least 2 of those 3 arbitrators. That Canon 10 describes special ethical obligations of party-appointed arbitrators who are not expected to meet the standard of neutrality otherwise prescribed by that code. Even those arbitrators, though, even those party-appointed arbitrators, if they are lawyers, are subject to rules of professional conduct in effect in the jurisdictions in which they are licensed to practice law, including the prohibition against negotiating for employment by a party or by a lawyer for a party to the arbitration case. So whatever the strictest rules of any of these codes that I've mentioned today, it's always the strictest rules that you have to comply with. For example, the jurisdictions in which I'm licensed to practice law are New York and Florida. Although I do hear quite a bit about California because I walk through the ethics world frequently, and so I've heard from California lawyers, so I'm going to include something for California lawyers in this presentation today. I don't know if any of you are licensed to practice in California, but some people who are listening to the record. Yeah, and Howard is. Okay. But I'm sure that there are people who will be listening to the recording of this presentation who are. So they'll be interested in that part of the presentation. In the New York Rules of Professional Conduct, definitions in Rule 1.0 that are relevant to this discussion, and provisions regarding communications in Rule 2.4 and the related comments of the New York Rules of Professional Conduct are substantially similar, but they're not identical to the respective provisions of the model rules. The New York rules do not contain a counterpart of Model Rule 3.9 regarding judges serving as neutrals, except that New York Rule 1.12a says that a lawyer shall not accept private employment in a matter upon the merits of which the lawyer has acted in a judicial capacity. So obviously, I don't think it would be difficult for most of us to understand if you've served as a judge in a case, you're not going to serve on the same conflict matter as a private lawyer after you cease to serve as a judge on the case. Rule 1.12 of the New York rules is entitled Specific Conflicts of Interest for Former Judges, Arbitrators, Mediators, or Other Third-Party Neutrals. Subsections B, C, and E of that New York rule are substantively identical to Model Rule 1.12 A, B, and D. So the numbering is different, but the substance is pretty much the same. Comment 3 of Rule 1.12 regarding obligation of confidentiality of third-party neutrals is substantially identical in both the Model Rule and the New York rules. Accordingly, similar though not identical to Model Rule 1.12C, New York Rule 1.12D states, when a lawyer is disqualified from representation under this rule, no lawyer in a firm with which that lawyer is associated may knowingly undertake or continue representation in such a matter unless the firm acts promptly and reasonably to notify, as appropriate, lawyers and non-lawyer personnel within the firm that the personally disqualified lawyer is prohibited from participating in the representation of the current client, implement effective screening procedures to prevent the flow of information about the matter between the personally disqualified lawyer and the others in the firm, ensure that the disqualified lawyer is apportioned no part of the fee from that representation, and give written notice to the parties and any appropriate tribunal to enable it to ascertain compliance with the provisions of this rule. And there must be no other circumstances in the particular representation that create an appearance of impropriety. The New York rule omits the Model Rules Comment 1 that defines personally and substantially, unfortunately. It also omits Comment 4 that expressly permits the screened lawyer from receiving a salary or partnership share established by prior independent contract. And it also omits Comment 5 advising that the notice, including a description of the screened lawyer, prior representation of the screening procedures employed, generally be given as soon as practicable after the need for screening becomes apparent. So some of those model rule provisions are omitted, but New York rules have added some additional requirements and restrictions that have to be consulted before you make a decision of what you can do after a case. The amendments effective on January 1, 2025 to the New York Rules of Professional Conduct, Rule 1.12, to the rules the amendments that were effective January 1, 2025 do not affect New York Rule 1.12, but the New York State Unified Court System Office of Court Administration proposed on December 26, 24, amendments to Rule 1.12 of the New York rules, of which the substantive changes that are relevant to neutrals are the following. Regarding imputed disqualification to the firm of a disqualified lawyer neutral, the required written notice to parties and appropriate tribunal would be qualified by a statement that accepted that notice need not be given if the notice would disclose confidential information protected by Rule 1.6, and in that case, the notice may be temporarily postponed, but shall be sent promptly after such confidential information is known by the parties in tribunal or is otherwise no longer protected by Rule 1.6. It's also proposing an amendment that the requirement that is not in rule professional conduct of the model rules 1.12, that there be no other circumstance in the particular representation that creates an appearance of impropriety. That appearance of impropriety requirement or lack of appearance of impropriety requirement would be deleted from the New York rule, as it is currently omitted from the model rules. Now, I am a member, as I mentioned, of the New York City Bar Association's Professional Responsibility and Discipline Committees, and the leadership of those committees have been requested to comment on these amendments, these December 26, 2024 proposed amendments to the New York rules by February 14. And I did submit my comments to the leadership of both of those committees, and my comments, in addition to some very substantial scrivener's errors, which was surprising, typographical errors and miscitations and so forth. But the substantive comments that I made to the leadership of both of those committees were the following. I think that temporary postponement of notice to parties and the appropriate tribunal of a conflict of interest to enable it to ascertain compliance with the screening and no fee apportionment requirements of Rule 1.12 is dangerous and anathema to persons concerned about conflicts of interest. I think confidentiality is very important. I'm a big proponent of confidentiality in a lot of contexts, but I think conflicts of interest in a situation where you have a disqualified lawyer because there is he or she was involved in a previous case, and the question is whether or not information that arbitrator, that neutral gained while being an arbitrator, or perhaps some viewpoints that arbitrator attained while in that capacity could somehow taint representation of a party by other lawyers in the firm. I don't think that notice should be postponed. I think that's something that the parties are entitled to know about immediately. Confidential information or otherwise. There are ways to consider out how to wall out some of that confidentiality, but I think that the information regarding the conflict of interest must be shared immediately. Also, my other substantive comment is that the no appearance of impropriety standard is, I acknowledge, vague and subjective. The concept of no appearance of impropriety is worth retaining, particularly in a current climate of erosion or abolition of long accepted norms and legal interpretations. What I recommend, instead of omitting or deleting that standard, is that we retain it, but add to the end of it, as determined reasonably by independent counsel having no interest or involvement in the circumstances or representation. So in other words, turn what would be otherwise a vague and subjective standard into a precise objective standard, a reasonability test as determined by an independent lawyer who would be analyzing the same circumstances. And if we have time at the end, we can talk about your thoughts about those proposed amendments and whether you agree with me or disagree with me and why. Now I'll turn to the Florida Rules of Professional Conduct that were effective on May 22, 2006, as they've been amended piecemeal since then. Again, they have definitions in Rule 1.0 that are relevant to this discussion, and provisions regarding communication regarding the roles of arbitrator or neutrals versus the roles of lawyer advocates in Rule 2.4, and related comments. And the Florida versions of those are substantially identical to the respective provisions of the Model Rules of Professional Conduct, unlike New York's. The Florida Rules of Professional Conduct does not contain a counterpart of Model Rule 3.9 regarding judges serving as neutrals. Rule 1.12 of the Florida rules, entitled Former Judge or Arbitrator, Mediator, or Other Third-Party Neutral, that's referenced in the comments to Rule 2.4, of the Florida rules, and the comments to Florida Rule 1.2 are substantially identical to the Model Rule 1.12 and its comments. Now, so I don't have to spend too much time on Florida. We've talked about the model rules, and Florida is pretty much the same. But we can spend time on California, which, of course, as we would expect, is an outlier. The California Rules of Professional Conduct, effective November 1, 2018, as amended, also contains definitions. In this case, it's in Rule 1.0.1, and they have provisions regarding communications regarding the role of the neutral versus the advocate lawyer in Rule 2.4 of the California rules, and related comments of the California rules. They are similar but not identical to the respective provisions of the Model Rules of Professional Conduct. The California rules omit the counterpart to comment 3 of the Model Rule 2.4 that would require informing unrepresented parties of the important differences between the lawyer's role as a third-party neutral and a lawyer's role as a client representative, including the inapplicability of the attorney-client evidentiary privilege. That's surprising for California, that they would take a less restrictive rule than the Model Rule. The definition of informed consent in California means a person's agreement to the proposed course of conduct after the lawyer has communicated and explained material risks, but California also requires disclosure of the relevant circumstances and including any actual or reasonably foreseeable adverse consequences of the proposed course of conduct. And the California rule omits the definition of confirmed in writing. And you'll see, as I mentioned earlier, when we get to writing or get to the requirement of informed consent, that California does not require that the informed consent be confirmed in writing. So, of course, they don't need a definition of confirmed in writing. The definitions of writing, firm, reasonable belief, screening, tribunal, they're pretty much the same as the Model Rule. I did not find in the California rule a counterpart to Model Rule of Professional Conduct Rule 3.9 regarding judges' service as neutrals, but because the California rules are not organized in the same structure as most state rules are and the model rules are, I may have missed it if it's there, or it may be buried somewhere else or in a comment. The California Rule 1.12 regarding service by a neutral as a lawyer advocate after ceasing to be an arbitrator in a case involving parties or lawyers, that for which it subsequently was served. That Rule 1.12 is substantially similar to the Model Rule 1.12, except that informed consent to representation by a lawyer in connection with a matter in which the lawyer participated personally and substantially as a neutral need not be confirmed in writing, as I said. And the lawyers in a firm with which the disqualified lawyer is associated may not undertake or continue representation in the matter if the disqualification arises from the lawyer's service as a mediator or settlement judge. Even if the screening, written notice to parties, and appropriate tribunal and no apportionment of fee conditions are satisfied. So it is an absolute bar in California. The California rules omits the counterparts of the Model Rules Comment 3 regarding the obligation of confidentiality of third-party neutrals. Comment 5 advising that the notice, including a description of the screened lawyer's prior representation and of the screening procedures employed, generally be given as soon as practicable after the need for the screening becomes apparent. But it does include Comment 1, happily defining personally and substantially. That definition is much more substantial, more extensive than the definitions of personally and substantially in the Model Rule comment or in the New York Rule. And I think we have time for me to read it quickly. Personal participation includes both direct participation and the supervision of a subordinate's participation as it may occur in a chambers with several staff attorneys or law clerks. Substantial participation requires that a lawyer's involvement was of significance to the matter. Participation may be substantial even though it was not determinative of the outcome of a particular case or matter. A finding of substantiality should be based not only on the effort devoted to the matter, but also on the importance of the effort. The personal and substantial participation may occur when, for example, the lawyer participated through decision, recommendation, or the rendering of advice on a particular case or matter. However, a judge who was a member of a multi-member court and thereafter left judicial office to practice law is not prohibited from representing a client in a matter pending in the court, but in which the former judge did not participate or acquire material confidential information. The fact that a former judge exercised administrative responsibility in a court in a court also does not prevent the former judge from acting as a lawyer in a matter where the judge had previously exercised remote or incidental administrative responsibility that did not affect the merits, such as an uncontested procedural duties typically performed by a presiding or supervising judge or justice. The term adjudicative officer includes such officials as judges pro tempore, referees, and special masters. Now I'll turn to now having talked about 3 states' rules as well as the model rules, I'll turn to the other sources of information regarding ethical obligations of arbitrators and mediators and other neutrals. The ABA and American Arbitration Association Joint Code of Ethics for Arbitrators in Commercial Disputes, that has been effective since March 1, 2004, does not supersede, by its own terms, does not supersede, and should be read in conjunction with agreements of arbitration parties, arbitration rules to which they agreed, applicable law, and other applicable ethics rules, all of which should be construed by the arbitrators. Based on the presumption of neutrality, that is, independence and impartiality, for all arbitrators, including third-party appointed arbitrators established by that code, and their fundamental duty to preserve the integrity and fairness of the arbitral process, Canon 9C2 provides where party-appointed arbitrators conclude that the parties intended for them not to serve as neutrals, they should so inform the parties and the other arbitrators. So in other words, we got about three arbitrator panel, and two of them are appointed by parties, and it's the expectation that those arbitrators that are so appointed are going to be less than neutral. That needs to be expressly disclosed to everybody involved in the arbitration case, the lawyers for both sides, the parties on both sides, as well as, of course, the platform, whether it be American Arbitration Association, JAMS, or FINRA. Canon 1C provides, for a reasonable period of time after the decision of an arbitration case, persons who have served as arbitrators should avoid entering into any business, professional, or personal relationship, or acquiring any financial or personal interest, which is likely to affect impartiality, or which might reasonably create the appearance of partiality in circumstances which might reasonably create the appearance that they had been influenced in the arbitration by the anticipation or expectation of the relationship or interest. So this is the applying for employment with a party or their counsel to an arbitration case after the case is concluded, or even accepting appointment as an attorney for a party, unless you are a third party appointed non-neutral arbitrator. Canon 6C, after an arbitration award has been made, it is not proper for an arbitrator to assist in proceedings to enforce or challenge the award. This is a specific example of what Canon 1C said more specifically. Canon 6B, although the attorney-client privilege does not apply to the relationship between an arbitrator and a party, the arbitrator should keep confidential all matters relating to the arbitration proceeding and decision. So for concerns about other members of the firm being walled off by screening and by economic factors such as not sharing in fees on a new case that rises after the arbitration case, that's all in aid of maintaining confidentiality, which is a very high level of concern in arbitration proceedings. Now, the model rules of conduct for mediators is adopted by the ABA, the American Arbitration Association, and the Association of Conflict Resolution since September 2005, provide in standard IA2 regarding self-determination of each party. Where appropriate, a mediator should make the parties aware of the importance of consulting other professionals to help them make informed choices. So in other words, tell the parties if they don't have a lawyer, you should get a lawyer. You don't have a CPA, and this is a case that involves complex tax or accounting related matters, you should get a CPA or a tax lawyer. Standard 2, regarding impartiality, a mediator should neither give nor accept a gift, favor, loan, or other item of value that raises the question as to the mediator's actual or perceived impartiality. That, of course, would include by implication, accepting an offer of employment, or representing a party after a mediation case, or actively seeking to be employed. Standard 3F, regarding past, present, potential, personal, or professional conflict of interest of a mediator, subsequent to a mediator shall not establish another relationship with any of the participants in any matter that would raise questions about the integrity of the mediation. The mediator should consider factors such as time elapsed following the mediation, the nature of the relationships established, and the services offered when determining whether the relationships might create a perceived or actual conflict of interest. So in other words, there's no bright line black letter rule on how long you need to wait after you've served as an arbitrator or a mediator in a matter, in this case mediation, because we're talking about the mediator code. But you err on the side of never, but there may be some circumstances depending upon the nature of the case and how different the proposed cases from the current one, even though they may have a slight bit of overlap, the code does permit some judgment in that regard. In that case, what I would recommend that I have opined on as an expert witness in circumstances like this is that if there's any doubt, get the opinion of a third party independent lawyer with no stake and no skin in the game, whether or not you're far enough removed from the case in which you served as a mediator to be involved in the new relationship that you're seeking to be involved in. Standard 5 of the model standards of conduct for mediators regarding confidentiality maintained by a mediator is the sort of the general blanket confidentiality rule that's informed all these concerns about screening and not sharing in fees and not serving as an advocate in a matter with respect to which you served as a neutral. Standard 6A5 regarding quality of process, a mediator should distinguish between the roles of mediator and other professionals. That's what we were talking about in Rule 2.4 earlier of the model rules and of the various state rules. And we have one more section to cover before we take questions and general discussion, and that's FINRA Dispute Resolution Services Arbitrator's Guide. Part 3 includes the arbitrator's role, ethical considerations. It's pretty succinct. It doesn't cover nearly as much as the codes or the model provisions for model standards for mediators cover, but it does acknowledge that in addition to the code of ethics for arbitrators of commercial disputes, which FINRA arbitrators are required to follow, even though FINRA did not expressly adopt that code, it is by implication adopting it by this rule. Arbitrators should also be mindful of any ethical considerations associated with the respective professions. So lawyers, you got to look to your rules of professional responsibility first. For example, duties of impartiality, neutrality, fairness, and perception of fairness, and avoiding entering into any financial, business, or other relationship that is likely to affect impartiality or might reasonably create an appearance of partiality or bias. For example, an arbitrator should not accept any engagement involving a party while an arbitration case is pending, nor do so for a reasonable period of time after the case concludes. And again, whenever you see the word reasonable, that means an objective standard. That's not a subjective standard. That means if you go to an independent, a reasonable, independent, informed lawyer who doesn't have skin in the game and ask that lawyer, is it reasonable now for me to start representing, one of the parties that was a party to an arbitration matter that I handled 20 years ago that had nothing to do with this case? If that reasonable independent lawyer says, yeah, I think it's reasonable, you could do it at this point, enough water under the bridge, then, and you get it in writing, and you inform all the parties, of course, everybody involved that you had this relationship in the past and served as an arbitrator, and nobody objects, then I don't think you have a serious legal malpractice risk for doing that. FINRA Commercial Arbitration Rule 12405 similarly requires arbitrators to disclose on an ongoing basis any direct or indirect financial or personal interest in the outcome of the arbitration, as well as any existing or past direct or indirect financial, business, professional, family, social, or other relationships with any of the parties, representatives, witnesses, or co-panelists. And I will now open for any questions or comments or anything you'd like me to repeat, because I went through this pretty quickly. Silence.
I was just going to
Is this
say, I
gonna-
think the DRS section is working on new rules for mediators.
Right. I know that DRS has issued rules recently regarding the discovery. It doesn't directly affect ethical obligations, but I know that they're in the process of reviewing all of their rules, all of their codes, the industry and the consumer codes, and making some substantial changes to it. So that definitely is in the works. Good news is FINRA, I believe, I have to go back and double check it, but I believe it is an agency. It is not a governmental agency. It's a quasi-governmental agency. It is a successor to the NASD. So it is not part of any branch of the federal government. And so I am hopeful that they are not losing staff.
The changes you mentioned that the DRS were making, will those apply? Are those going to be to the model standards of conduct?
It would change. It could change. I don't know. I haven't heard that they're affecting the guide that I just summarized. the ethics rules, but it would affect the codes, the consumer and the industry codes.
I
But it's
don't know.
possible. I mean, everything is up for debate.
So my question is, are the model standards of conduct for mediators, is that what the DRS is looking at?
No. DRS is that's the FINRA. That's the Financial Industry Regulatory Authority Dispute Resolution Services. That's just they could change the regulations and the rules applicable only to their arbitrators and mediators.
Oh, okay. I thought when she said DRS, it was the dispute resolution.
Yeah, that's part of it. That's the arbitration mediation section of FINRA.
No,
FINRA has
no,
two
when I
arms. It
said
has broker
DRS,
regulation and it has arbitration mediation.
when I was talking about DRS, I'm talking about the ABA dispute resolution section, okay, is working on the ABA rules for.
Oh, I'm sorry, I
model rules for
misunderstood.
mediators.
But you meant by DRS. I'm sorry.
No, yeah, so, yeah, it's the ABA dispute resolution section is working on the model rules. I think you said, Karen, that they're from 2004 or 2005. And
Right.
there's reporters that are really doing a bang up job on it. They had a whole presentation, webinar, seminar, whatever, on what they were working on, and they're hoping for them to come out, I think, in the spring. And they may be,
You're talking about the model standards, right? You're talking about the model standards, not the model rules of professional conduct.
no, not the rules of professional conduct, I'm talking about for mediators.
Mediators, right?
Yeah.
Right. That was right. That was actually, it was adopted and revised. It actually came out and was adopted in 2005, but it was written in 2004. Right.
Yeah.
Well,
In fact, I think, and if I get it, I'll share it, because I'm on a listserv, of the New York City dispute resolution listserv. The people who are working through are on that, and they said they're gonna send it out to the listserv for people to give feedback. So if I actually get it, I'll share it with, Karen and whoever, to share it with everyone else.
Okay. Does anyone else have any questions or comments on my topic tonight?
Will a recording of this be available?
Yes.
Good.
It will be.
So
I
could
believe
you-
all. Yes, all of our programs are that are recorded are posted on our page, the ADR committee page of the Senior Lawyers Division. And we have quite a few posted there. If you want to go back and look at some of the earlier ones, including Howard's is posted there now. And there was an earlier one about a year ago, also on international arbitration, that we posted a year ago. I just want to alert you when I started at the beginning, if you all have any comments or questions about my topic of my presentation, please interrupt me. But if we have a few minutes left, I just want to bring you up to speed about what's happening with the ABA. May or may not have heard, I don't know how much of this is in the mainstream media, but employees, particularly lawyer employees of a significant number of federal government agencies, have been prohibited by order of the heads of those agencies from being members of the American Bar Association, and at the very least have been prohibited from being reimbursed by those agencies for their dues as being members of the American Bar Association. This is something that has happened within the last week or two. The leaders, I'm not at the leadership level at the Senior Lawyers Division, so I wasn't invited. But last Friday afternoon, I think it was 3:00, the leaders of all the sections and divisions of the ABA met virtually to discuss a strategy for dealing with this. It's broader than that. The edict is not only lawyers cannot be members and will not be reimbursed for the membership dues, the reimbursement of the membership dues being obviously the least of the problems. We could figure out a way around that. But they're prohibited from being members of the ABA. They're also prohibited from participating in any programs of the ABA, meaning they cannot speak on panels, they cannot attend ABA events or conferences, they cannot contribute to deliberations of substantive committees of the ABA, work that those substantive committees are doing on drafting reports and statements and resolutions and the like. They're essentially being walled off from the American Bar Association. I'm not going to speculate as the motivation, but I think we can all come to our conclusion on what the motivation for that would be. I will say I counted a mini version of this when I was spending more time in Florida than I do now. I don't spend any time in Florida now. But I'm still licensed to practice law in Florida. And I had shortly after I gave a webinar as part of this committee, actually, for the ABA, the CLE program. The Florida Supreme Court announced that no ABA programs, CLE programs, would be acceptable for CLE credit for lawyers licensed to practice law in Florida because the ABA had a policy and continues to have a policy of diversity, equity, and inclusion on panel membership. So that was some discussion back and forth and some fighting for a year or so of that, and eventually the ABA caved to a limited extent. And no longer has a hard and fast rule on panel membership, but as a matter of policy, as a practical matter, continues to observe that policy. And so the Florida Supreme Court relented, and now ABA programs are now eligible for CLE credit for lawyers licensed to practice law in Florida. That was, of course, before January 2025. In a previous era. And, that was sort of the tip of the iceberg. I like to use the expression tip of the iceberg. I used it in a webinar I gave in this group. And of course, now we have the real thing. So just want you to be aware of that. And Linda has seen this because she, like me, are members of the, I don't want to keep you past time, so I'm not going to read the whole thing unless I can get it in quickly. We're both members of the DR section. You probably have seen, there was a statement issued by the ABA president on this topic that you all should have received. I haven't seen anything yet from the chair of the senior lawyers division. She may be working on something. Karen may be working on something now. Correct me if I'm wrong. I haven't seen a statement from her expressly on this issue, but this is a statement that was issued that I received today from the chair of the dispute resolution section, of which Linda and I are both members. In these changing times, and please excuse me if I get emotional about this because this is a big deal to me. In these changing times, the American Bar Association has reaffirmed its steadfast commitment to the fundamental principles of the rule of law and the values of diversity, equity, and inclusion that are essential to a fair and just legal system. President Bill Bay's statements on behalf of the ABA's position on these critical issues can be reviewed here. And it's attached to this statement. As dispute resolution professionals, we play a unique and vital role in ensuring access to justice, fostering civility, and upholding the integrity of our legal system. Many of you have reached out in response to President Bay's statements, and I want to ensure that all members of our section are fully informed of the ABA's position and the collective support for these guiding principles. The section of dispute resolution stands firmly in alignment with the ABA's commitment to the rule of law and to the core belief that justice must remain accessible, impartial, and fair. We also continue to champion the principles of diversity, equity, and inclusion, values that strengthen our profession and enhance our ability to serve those who turn to us for resolution. I encourage you, as leaders in the legal community, to use your voices and expertise to support these efforts where you feel appropriate, whether through your practice, your scholarship, or your engagement with colleagues and the public. Your contributions make a difference. Now more than ever, our work in resolving disputes, building understanding, and ensuring fair processes is essential to upholding the foundations of justice. Personally, I am proud to be part of this organization and to stand alongside such dedicated professionals in advancing these important ideals. I invite you to share the ABA's message with your networks and to join in demonstrating the legal community's unwavering commitment to the rule of law and a just society. By way of example, check out my recent posting on the importance of defending the rule of law. Now is the time to speak up, share your thoughts, and support each other. Your voice matters. Thank you for your dedication to our profession and to the principles that guide our work. Together, we can ensure that justice remains strong and accessible to all. Warm regards, Susan Guthrie, Chair, ABA Section of Dispute Resolution.
May I ask a question? I was not aware of this new thing that bars government employees from being members of the ABA.
Right.
Do you know if our leadership is in fact challenging that on constitutional grounds, freedom of?
I'm sure that there are, I mean, I'm sure that there are other, whether our section is doing anything, I don't know. I know that in the business law section, there are a couple of committees that are working on it directly.
Okay.
That would be a violation of freedom of expression. You can't become a member of the ABA. I never heard
Well,
of that.
I'm old enough to remember, and maybe some of you remember, my father was, I remember a couple of things from my youth. My father was a very senior scientist in the federal government. He worked I started originally in the Commerce Department and eventually it became NOAA. NOAA, you may have heard, is one of the agencies that's being attacked. My father is not here to see this, thank goodness. But I do remember that in the 50s, I was old enough to be able to witness the HUAC proceedings. In fact, at the age of 4, I was put in front of a television set, 12 inches by 12 inches, to watch those proceedings. And I was told to sit there and watch them and to remember them. It's one of the reasons I became a lawyer. It's beyond fathomable, but what we need to do is to keep clear heads, not to point fingers, not to behave in a way that would impugn our own impartiality. As a matter of fact, in the program that we're going to be giving, the career development program that we'll be giving in March, the panelists are 3 relatively young neutrals. They have been admonished not to mention any political party or any politician by name. And they're going to talk about how to navigate as a neutral or someone who wants to become a neutral in this environment. I don't know, I'm not responding to your question, but the point
Yes, you are.
is, but I mean, you get the point. We need to keep our head down, but move forward. I guess the point I was going to make is, one of the in that situation in the 50s, my younger brother and I were told we were not to say anything to anybody anytime about where my father worked. What his duties did, anything we overheard anything when he came home, we weren't, was allowed to speak about that. We never talked about how anybody voted. And we're
Well,
in that realm.
I think I must be a drop older than you are. I can remember my parents sitting me down and watching a distinguished member of the Massachusetts bar push back at Senator McCarthy. And so I mean, I had not heard of what you just mentioned today about this blockage, but as a former member of the commission staff, the idea that you can't participate in panels or programs or respond to inquiries is just
I heard about
bizarre.
this as a member of a listserv of a committee of the business law section. Someone on that committee that came out somehow had access to it. I think he knew somebody in one of the federal agencies who had received this memo and circulated it to the committee.
That's bizarre. Bizarre. All right.
So, I mean, the bottom line is, we do all have to be, that's why I'm urging you all, please, and encourage anybody you can to come to Ethics and Professional Responsibility Committee meetings of the Senior Lawyers Division, because we're going to be exploring what we can do in the context of the rules of professional conduct or resolutions of the House of Delegates or state white papers or statements or resolutions. I mean, if you listen to certain people, the problem may go away in 30 days or 60 days. But I don't think we can count on the problem going away in 30 days or 60 days unless we do something.
I just did a little research, quick, at Google,
I heard the
Googled this.
typing.
Yeah, I can't. What I see is from news that the ABA poses any DEI probes into bar associations. I haven't read this, but that I understand, and an investigation is one thing, but actually prohibiting government lawyers from being members of, where do you find that information?
The memo was circulated. I don't remember whether it was a letter or a memo, but it was a memo to staff or a letter to staff of a particular agency. And then I subsequently heard in the same listserv that the same memo was circulated in other agencies, a number of other agencies.
I read it in
Uh,
news, something on the new, a news thing that came out. And this was about 2 weeks ago, and it was one of the agencies, I don't know if it was the FTC or whatever, but they were setting all kind of rules, and literally what I read said, because the ABA was this liberal ... group,
Yes,
they were
yes, that's the one.
outright saying it, radical,
Yes.
whatever,
Yes, that's exactly. I don't recall whether the original one I saw was from the FTC. It may have been the FTC. But I don't remember off the top of my head, but I could search it because I kept a copy of it, obviously. But it's yes, that's exactly how it started.
I got to get to the bottom of this. A DEI, disagreeing with the government's position on DEI right now is one thing, but prohibiting lawyers from being a member of the ABA is.
No, I think it goes beyond, Howard. I think this particular action goes beyond the DEI concern. I think
Yes.
what it seems to be the concern is that the ABA has taken. You're not following all of these, but the House of Delegates of the ABA in January issued a number of resolutions that were directly critical of certain executive orders, not exclusively DEI, but others as well. And the American Bar Association in the past has issued statements. I mean, I remember ringing in my ears. I remember the support of the American Bar Association of Justice Barrett. And I said, I said to all of my colleagues at the time, and I said, I know you're all angry about this. Wait, this is going to be a good thing, because this is going to show that the American Bar Association isn't all one side. Someday we're going to need to cite to the fact that they recommended Barrett for the Supreme Court as proof that we're not political. So, and guess what? I mean, in fact, we're using that now.
I'm sorry, I gotta run, I have another meeting.
That's all right, it's 7:00. But thank you all very much. Please, if you sign up, register to become a member of the Ethics and Professional Committee, Professional Responsibility Committee, and you'll get an invitation to our next meeting. And it's going to be a non-recorded, no minutes circulated strategy action plan committee. That's what that meeting is for. So please come and bring your ideas and tell everyone that you know in the ABA to do the same.
Okay. Good night.
Have a great evening, everybody. Thank you for your patience.